If you are a gun owner in Virginia, the past 30 days have changed everything. On May 14, 2026, Governor Abigail Spanberger signed Senate Bill 749 and House Bill 217 into law. The AR-15, the AK pattern rifle, modern sporting rifles, standard capacity magazines. All of them are now banned from sale, purchase, manufacture, import, and transfer in Virginia starting July 1st, 2026. This is not a rumor. This is not a proposed bill. This is signed law with a countdown clock. You have weeks, not months, to understand exactly what this law says, what it does and does not ban, and what your legal rights are right now. Before we go any further, subscribe. Because this law was signed 5 weeks ago and the lawsuits have already been filed, and the critical decision on whether a court will pause this law before July 1st could come any day. I am going to make sure you understand every development as it happens. Hit that subscribe button right now. Let me start with the basics of what this law actually is. Virginia has just become the 12th state in America to enact an assault weapons ban. The legislation had been blocked by previous governors. Democratic majorities in both chambers of the General Assembly passed it during the 2026 regular session. And Governor Spanberger, a former federal law enforcement officer who made gun restrictions a central campaign promise, signed it on May 14, 2026. Senate Bill 749 was sponsored by Senator Saddam Aslan Salim, a Democrat from Fairfax County. Its companion, House Bill 217, was sponsored by Delegate Dan Helmer, also a Democrat from Fairfax County. Together, these two bills create what is now the most significant gun restriction in Virginia in years. The law creates a new category of prohibited items called assault firearms and large-capacity ammunition feeding devices. Starting July 1, 2026, it is a criminal offense for any person to import, sell, manufacture, purchase, or transfer an assault firearm or a large-capacity ammunition feeding device in Virginia. Let me be very specific about what that means because the definition of assault firearm is where this law gets complicated and where dealers, buyers, and even some attorneys are still parsing the details. Under SB 749 and HB 217, the term assault firearm covers three main categories. First, semi-automatic, centerfire rifles with a detachable magazine and at least one of a list of specific features. Those features include a folding or telescoping stock, a pistol grip that protrudes below the action of the weapon, a thumbhole stock, a grenade launcher or flare launcher, a flash suppressor, a forward pistol grip, a barrel shroud, a threaded barrel capable of accepting a flash suppressor, a folding, detachable, or thumbhole stock, or a second hand grip. This feature-based definition means that a modern sporting rifle like an AR-15, which commonly has a pistol grip, telescoping stock, and flash suppressor, falls squarely within the definition of an assault firearm under Virginia's new law. Second, semi-automatic pistols with a detachable magazine and specific features. Prohibited features for pistols include a magazine that attaches outside the pistol grip, a threaded barrel capable of accepting a barrel extender, a flash suppressor, forward hand grip or silencer, a shroud that is attached to or partially encircles the barrel and permits the shooter to hold the firearm with the non-trigger hand without being burned, an unloaded weight greater than 50 ounces, or a second hand grip. Third, semi-automatic shotguns with specific features. These include a folding or telescoping stock, a pistol grip that protrudes conspicuously beneath the action, a fixed magazine with a capacity to accept more than 5 rounds, and detachable drum magazines. On large-capacity ammunition feeding devices, the law bans magazines capable of holding more than 15 rounds. This applies to ammunition feeding devices for any firearm, meaning both rifle and handgun magazines above 15 rounds are prohibited from sale, manufacture, purchase, import, or transfer. There is one important amendment that Spanberger proposed and incorporated into the signed legislation. She added an exemption for certain semi-automatic shotguns commonly used for hunting. When signing the bill, Spanberger acknowledged that the General Assembly had not adopted all of her preferred language on hunting exemptions and indicated she would continue working with the bill's sponsors to refine the language. That means the hunting exemption language may still be somewhat ambiguous in the current text and will likely need to be clarified either through the legislature or through court interpretation. Now let me tell you about the penalty structure because this is where the stakes become very real. A violation of the prohibition on importing, selling, manufacturing, purchasing, or transferring an assault firearm is a Class 1 misdemeanor in Virginia. A Class 1 misdemeanor in Virginia is punishable by up to 12 months in jail and a fine of up to $2,500. But here is what most people are not focusing on. A violation also triggers a 3-year prohibition on possessing, purchasing, or transporting any firearm whatsoever. So if you violate this law, even on a first offense, even as a misdemeanor, you lose your ability to lawfully possess or purchase any firearm in Virginia for 3 years. That means a single transaction involving a banned firearm could effectively suspend your Second Amendment rights for 3 years under Virginia law. That is a significant consequence that goes far beyond the immediate fine. If you're finding this important and urgent, subscribe right now. Because the court hearings on whether to pause this law before July 1st are being scheduled right now, and I will have live coverage and analysis of every development. Subscribe so you don't miss a single update. Let me tell you about the grandfather clause because this is the question most Virginia gun owners are asking. If you already own a firearm or magazine that would be banned under SB 749, you can keep it. The law includes a grandfather provision. If you lawfully purchased and possessed a covered firearm or magazine before July 1st, 2026, the sale and transfer prohibitions do not apply to your continuing possession. You do not have to surrender your existing banned firearms and magazines. You do not have to register them with the state. You do not have to modify them. But here is the critical limitation that gun rights advocates are furious about. The grandfather clause only protects your continued possession. It does not let you sell, transfer, donate, or pass the firearm to your heirs while still in Virginia. The Sportsman's Alliance described this as permanently freezing the market, meaning you can never replace, upgrade, or legally pass these common tools down to the next generation of hunters and shooters within the state. If a grandfathered firearm is stolen and you want to replace it, you cannot buy the same model in Virginia anymore. If you die and leave your AR-15 to your adult child in Virginia, that transfer could be prohibited. The grandfather clause keeps you whole for your existing collection, but it locks Virginia's market for these firearms permanently going forward. And a permanent freeze on the market for the most popular rifle category in America is precisely what gun rights organizations say violates the Second Amendment. Now let me tell you about what happened in the minutes and hours after Governor Spanberger signed SB 749, because the legal response was the fastest I have ever seen in gun rights litigation. Within minutes of the signing, before the ink had even dried, the National Rifle Association, the Firearms Policy Coalition, and the Second Amendment Foundation filed a federal lawsuit in the United States District Court for the Eastern District of Virginia. The case name is McDonald v. Katz, case number 1:26-CV-01305. The plaintiffs include 2 Virginia residents, Justin McDonald of Goochland County and Anthony Groneveld of Prince William County, along with the 3 major gun rights organizations. The defendants are Virginia State Police Superintendent Colonel Jeffrey Katz, along with the Commonwealth's attorneys and sheriffs of Goochland and Prince William counties. The complaint is 24 pages long. It is filed in the Alexandria Division of the Eastern District of Virginia, a court known in legal circles as the Rocket Docket because of how quickly it moves cases. The attorneys representing the plaintiffs are David H. Thompson, Peter A. Patterson, and William V. Bergstrom of Cooper & Kirk, PLLC, one of the top constitutional litigation firms in the country. They are joined by P. Thomas DeStanislao and Michael Brady of Whiteford, Taylor and Preston, LLP. The central argument of McDonald v. Katz is straightforward and powerful. The firearms Virginia bans as assault firearms are, in all respects, ordinary semi-automatic firearms. The lawsuit argues that AR-15-style rifles and standard-capacity magazines are in common use by law-abiding citizens for lawful purposes including self-defense, hunting, and sport shooting. Under the Supreme Court's decisions in Heller, Bruin, and Catano, the government cannot ban arms that are in common use for lawful purposes. To be banned under established constitutional precedent, an arm must be both dangerous and unusual. Arms that are in common use cannot be unusual. Therefore, they cannot be dangerous and unusual in the constitutional sense, and therefore, they cannot be banned. The complaint puts the case in stark terms. By prohibiting the plaintiffs from acquiring common semi-automatic firearms and ammunition magazines, the lawsuit argues, Virginia has prevented them from keeping and bearing arms within the meaning of the amendment's text. FPC President Brandon Combs was even more direct in his public statement. He said, Spanberger's insane law criminalizes constitutionally protected conduct and bans arms the Second Amendment protects. We're going to force Governor Spanberger and other government officials to follow the Constitution and respect the Second Amendment, full stop. But McDonald versus Katz was not the only lawsuit filed. Not even close. Let me walk you through all the legal challenges because the breadth of the response is remarkable. The day after Spanberger signed the bill, May 15, 2026, the National Shooting Sports Foundation funded a second lawsuit filed in Virginia State Court. This case is called Black versus Hook and was filed in the Circuit Court of Fauquier County. The plaintiffs are two Virginia residents named Eric Black and Britton Condon, along with three industry plaintiffs, Clark's Gun Shop doing business as Clark Brothers, Optimus Arms LLC, and Hexmag USA LLC. The defendant is Scott C. Hook, the Commonwealth's attorney for Fauquier County. The Black versus Hook complaint goes further than the federal case. It argues that SB 749 violates not only the United States Constitution, but also the Virginia Constitution. A third lawsuit was filed by Gun Owners of America, Gun Owners Foundation, the Virginia Citizens Defense League, the Virginia Citizens Defense Foundation, and individual plaintiff John Crump, a firearms journalist. This case was filed in the Circuit Court for the County of Lancaster in Virginia State Court. Hey, 73% of people watching right now are not subscribed. If you are a Virginia gun owner, or if you care about what Virginia's law could mean for the rest of the country, this channel is going to be your most valuable source of information as these cases develop. Subscribe right now. And here is the development that changes the entire calculus of this litigation. Harmeet Dillon, the Assistant Attorney General for Civil Rights of the United States Department of Justice, publicly stated that the DOJ would file its own lawsuit challenging Virginia's assault weapon ban. The Trump administration's DOJ has already sued Colorado and the District of Columbia for their assault weapon bans. Virginia's signing of SB 749 immediately drew the same response. If the DOJ files in Virginia as Dillon promised, Virginia will be facing lawsuits from the federal government, from the NRA, from the Firearms Policy Coalition, from the Second Amendment Foundation, from Gun Owners of America, from the Virginia Citizens Defense League, from the National Shooting Sports Foundation's funded plaintiffs, and potentially more. This level of coordinated legal opposition is extraordinary. Let me explain why the Eastern District of Virginia, where McDonald versus Katz was filed, is a particularly significant venue. Virginia's Eastern District, specifically the Alexandria Division, is nicknamed the Rocket Docket because of how quickly it resolves cases compared to other federal courts. Cases that might take years to reach a decision in other districts can be resolved in months in the Alexandria Division. If the plaintiffs in McDonald versus Katz move quickly, they could obtain a ruling on a preliminary injunction before July 1, 2026, potentially pausing the law before it even takes effect. A preliminary injunction would require the plaintiffs to show they are likely to succeed on the merits, that they would suffer irreparable harm without the injunction, that the balance of equities favors an injunction, and that an injunction would serve the public interest. Under the Bruin framework, the plaintiff's argument about common use is extremely strong. AR-15 style rifles are unquestionably in common use. There are an estimated 24 million or more in civilian hands across the country. Virginia has hundreds of thousands of AR-15 owners. The argument that these rifles are in common use is essentially uncontested by any honest examination of the evidence. If the court agrees that the plaintiffs have a strong likelihood of success under Bruin, a preliminary injunction could follow, and if that happens, SB 749 would be paused, and the July 1, 2026 effective date would become a non-event. Quick legal note. This is educational information, not legal advice. Gun laws are extremely complex and fact-specific. Always consult with a qualified attorney about your specific situation. Now let me address something that every Virginia gun dealer and FFL needs to understand right now, because the compliance obligations for dealers are significant and the timeline is tight. Federal firearms licensees have until July 1, 2026 to audit their inventory against the 7 categories of assault firearms defined in the law. Pay particular attention to modern sporting rifles and modern sporting rifle pattern pistols. These are almost certainly banned under SB 749 as written. Dealers should stop accepting consumer orders for in-state retail delivery of these items immediately. Until either a court issues an injunction or the law is otherwise stayed, Dealers who complete transactions involving banned firearms after July 1st are at risk of criminal liability. The practical reality for dealers is stark. Virginia has been a major market for modern sporting rifles. AR-15 platform rifles have been among the best-selling firearms in the country for years. Dealers who have inventory in this category need legal counsel immediately to understand exactly which items are banned, how to handle existing orders, and what compliance looks like under the new law. The same applies to magazines. High-capacity magazines have been popular items in the Virginia market. After July 1st, dealers cannot sell magazines holding more than 15 rounds. Pre-July 1st stock that is not sold becomes essentially unsaleable in Virginia. Let me now talk about the broader national context of this law because Virginia does not exist in a vacuum. SB 749 and HB 217 are part of a coordinated national push by Democratic state governments to enact assault weapons bans before the courts can stop them. Let me explain what I mean. At the federal level, the Supreme Court's Bruen decision in 2022 created a new framework for evaluating gun control laws that is generally favorable to gun rights. Under Bruen, laws that restrict commonly owned firearms without adequate historical support are unconstitutional. The logical conclusion of Bruen's reasoning is that assault weapons bans, which restrict the most commonly owned category of rifle, are constitutionally suspect at best and unconstitutional at worst. Pro-gun states and gun rights advocates have been pushing this argument aggressively in courts around the country. In Maryland, a federal court has been considering challenges to that state's assault weapons ban. In California, challenges to the California ban continue. In Illinois, Judge McGlynn issued a permanent injunction finding PICA unconstitutional, though it is currently stayed by the Seventh Circuit. The Trump DOJ has sued both Colorado and the District of Columbia over their bans. The legal trend, while not uniform, is moving in a direction that makes assault weapons bans more constitutionally vulnerable than they have ever been. Virginia's Democratic leaders saw this trend and decided to move now, while they controlled both chambers of the legislature and the governor's office, to lock in an assault weapons ban before the courts potentially foreclose that option. Governor Spanberger herself acknowledged this dynamic. Opponents of the bill were blunt. The entire Republican delegation in the General Assembly opposed SB 749 and HB 217. They argued that the bills were unconstitutional under Bruen, that they would be immediately struck down in court, and that the Democratic majority was enacting a law they knew would be challenged and likely invalidated just to make a political statement. The Republican critics may well be right about the constitutional outcome, but the law is signed. It takes effect July 1st, unless a court stops it, and Virginia gun owners are living with that reality right now. Here is something important that Spanberger said at the signing that deserves close attention. She stated that while the General Assembly chose not to adopt her amendment that specifically carves out certain firearms frequently used for hunting, she would work with the patrons to clarify the language. This is a remarkable admission. The governor is essentially saying that in its current form, the law may be broader than she intended. She acknowledged there are firearms frequently used for hunting that she did not mean to ban, and yet she signed the bill anyway in its current form, without that clarification. Gun rights attorneys are already pointing to this statement as potentially useful in litigation. If the governor herself acknowledges uncertainty about the scope of the law, that ambiguity could support arguments that the law is overbroad and should not be enforced pending clarification. This is exactly the kind of ammunition, no pun intended, that litigators look for when building an injunction motion. Let me also address the Virginia constitutional angle because the state court cases raise arguments beyond the federal Second Amendment. Virginia has its own constitution. Article 1, Section 13 of the Virginia Constitution states that the right of the people to keep and bear arms shall not be infringed. Virginia courts have historically interpreted this provision. The state court cases, Black v. Hook and the GOA and VCDL case, argue that SB 749 violates not only the federal Second Amendment, but also this Virginia constitutional provision. Virginia state courts will have to apply their own interpretation of Article 1, Section 13. If a state court finds that SB 749 violates the Virginia Constitution, that ruling cannot be reversed by a federal court. It would be a binding determination of Virginia state law. This is why the state court cases are potentially even more significant than the federal challenge in some respects. Now let me walk through the 4 possible outcomes as this legal battle develops, all before July 1st, 2026. Outcome 1. a court grants a preliminary injunction before July 1st. If this happens, SB 749 is paused. The July 1st effective date passes without the law taking effect. Dealers continue selling modern sporting rifles and standard capacity magazines. The litigation proceeds on the merits. Gun owners breathe a sigh of relief, at least temporarily. Given the multiple lawsuits in both federal and state court, and given the rocket docket's speed, this outcome is genuinely possible before the end of June. Outcome 2. No injunction is granted before July 1st, but the law is later struck down on the merits. In this scenario, the law takes effect on July 1st. Dealers stop selling banned items. Gun owners who want to buy an AR-15 in Virginia cannot. The law is in effect for some period of time before a court eventually finds it unconstitutional. This is the most frustrating scenario for gun owners, because they have to live under an unconstitutional law for months or years while litigation proceeds. Outcome 3. The law survives preliminary injunction and is upheld on the merits. If the courts find SB 749 constitutional, Virginia's assault weapon ban stands. Gun owners retain their grandfathered firearms, but the market for new sales is permanently closed. This outcome requires courts to essentially reject or limit the Bruin framework in a way that permits categorical bans on commonly owned firearms. Given the current legal landscape and the Trump DOJ's position opposing these bans, this seems like the least likely outcome, but it cannot be ruled out. Outcome 4. The law is struck down before taking effect or very shortly thereafter. This would be the best-case scenario for gun rights advocates. A court finds SB 749 unconstitutional and enjoins its enforcement before the July 1st effective date. The law never actually restricts a single transaction. Here is what I recommend Virginia gun owners do right now, regardless of which way the litigation goes. First, if you have been considering purchasing a modern sporting rifle or any semi-automatic firearm with features that could be covered by SB 749, the time to make that purchase is before July 1st, 2026. Even if the law is ultimately struck down, there is no guarantee that happens before July 1st. If you want a grandfathered firearm, buy it before the deadline. Second, document your existing collection. Make a written record of every firearm and magazine you own, including when and where you purchased it. That documentation establishes that you are a grandfathered owner if the law takes effect and is later enforced. Third, contact your state legislators. Even though the law is signed, legislators can amend or repeal it. And the 2027 legislative session will be an opportunity to push for changes, particularly on the hunting exemption issue that Spanberger herself acknowledged. Fourth, support the organizations that are fighting this in court. The NRA, FPC, SAF, GOA, and VCDL are all spending significant resources litigating against SB 749. They need financial support to fight these cases to completion. Fifth, watch the courts closely. Follow NRA-ILA, FPC, and SAF for updates on the litigation. The rocket docket moves fast. There could be significant court decisions before July 1st that change the entire picture. Sixth, if you are a dealer or FFL, get legal counsel immediately. The compliance obligations are significant and the window to prepare is closing fast. Seventh, do not assume that because you have a grandfathered firearm, you have no legal exposure. The grandfather clause protects your possession. It does not protect you from other restrictions. Know exactly what the law permits for grandfathered owners and what it does not. Let me close with the biggest picture of all. Virginia joining the list of states with assault weapons bans, combined with the DOJ's opposition to those bans, creates exactly the kind of national conflict that could push the Supreme Court to finally take up the question it has been avoiding. Can states ban the most commonly owned category of rifle in America? That question has been percolating in the lower court since Bruin was decided in 2022. The Supreme Court has been relisting related cases without granting review. The emergence of Virginia as yet another state enacting a ban, combined with the Trump administration's aggressive litigation against state bans in Colorado, D.C., and now potentially Virginia, creates mounting pressure for the Supreme Court to answer the question definitively. Justices Kavanaugh, Thomas, Alito, and Gorsuch have all signaled they have serious questions about the constitutionality of assault weapons bans. That is 4 justices who appear sympathetic to the constitutional challenge. If one more justice joins that group, the Supreme Court strikes down assault weapons bans nationwide. That is the ultimate prize and ultimate risk that both sides in this debate understand. Virginia signing SB 749 is not just a state law, it is a move in a national chess match over whether the most commonly owned rifle category in America is constitutionally protected, and the answer to that question is going to come from 9 justices in Washington, not from Governor Spanberger in Richmond. Subscribe now because every development in McDonald versus Katz, in Black versus Hook, in the DOJ litigation, and at the Supreme Court is going to be covered on this channel in real time. You need to be subscribed to stay ahead of this story. The law takes effect July 1st, 2026. The clock is running. Stay informed and stay engaged. This is educational content and not legal advice. For your specific legal situation, consult a qualified firearms attorney licensed in Virginia.